What if I told you that the home you've spent 30 years paying off could be taken by the government after you pass away? And it's completely legal. This happens to thousands of American families every single year. It's called Medicaid estate recovery. And if your house is sitting in your own name right now, you need to watch this video before anything else today. Here's a situation that plays out more often than most people realize. A 78-year-old woman, let's call her Carol, spent her life working hard, raising her kids, and paying off her home in full. When she needed nursing home care, her family helped her apply for Medicaid to cover the $8,000 to $12,000 per month in costs. Medicaid approved her. She got the care she needed. Then Carol passed away. And within months, the state sent her family a letter, a claim against her estate for everything Medicaid had paid on her behalf. Her house, worth $280,000, was the main asset in that estate. The family had no idea this was even possible, but it is, and it happens in every single state. The program is called Medicaid Estate Recovery, and it's been federal law since 1993. The good news is that with the right planning, done early enough, you can protect that home completely. Let's walk through exactly how. Medicaid is the government health program that pays for long-term care, things like nursing home stays, memory care facilities, and in-home aids, when you can no longer afford those costs yourself. But here's what most people don't understand. Medicaid isn't free money. It's more like a loan against your estate. When you pass away, your state's Medicaid program has the legal right to file a claim against anything you owned and recoup what it spent on your care. In many states, this specifically targets your primary residence. Now, there are some protections built in. If your spouse is still living in the home, the state generally can't go after it while your spouse is alive. Same goes if a disabled child or a caregiver child who lived with you for at least 2 years still lives there. But once those protections no longer apply, that home becomes fair game. The average nursing home stay in the United States runs about 2.5 years. At $10,000 a month, that's $300,000 in Medicaid payments that the state may try to recover from your estate. Your house is often the only asset large enough to cover that bill. Now, you might be thinking, can I just transfer my house to my kids before I apply for Medicaid? That's where a lot of people make a very expensive mistake. Medicaid has what's called a 5-year look-back period. When you apply for Medicaid long-term care benefits, the government looks at every financial transaction you made in the 5 years before that application date. If you transferred your house to your children or sold it for less than market value, within that 5-year window, Medicaid will penalize you. They'll calculate how much care that home's value could have paid for and make you ineligible for Medicaid for that same period of time. For example, if your home is worth $240,000 and your state's average monthly nursing home cost is $8,000, that's a 30-month penalty. You'd be responsible for 30 months of nursing home costs out of pocket, right when you need Medicaid the most. This is why planning early, ideally before age 65 and absolutely more than 5 years before you think you might need care, is so critical. The clock on that 5-year window starts the day you make the transfer. So what's the right way to protect your home? The most widely used and legally sound strategy is something called an Irrevocable Medicaid Asset Protection Trust, sometimes shortened to MAPT. Here's how it works in plain English. You work with an elder law attorney to create a trust, a legal entity that holds ownership of your home. You transfer the deed of your home into that trust. Once you do that, the home is no longer considered your personal asset for Medicaid purposes. As long as more than 5 years pass before you need care, you still live in the home. You still benefit from any increase in its value. When you pass away, the home passes directly to whoever you named as beneficiaries, your children, your grandchildren, without going through probate and without being subject to Medicaid estate recovery. The key word here is irrevocable. Unlike a revocable living trust, you cannot simply take the house back. That's what makes it effective for Medicaid protection. You're giving up technical ownership in exchange for protecting it. Many people in their late 50s and early 60s who are still healthy are ideal candidates for this strategy. If you're 62 years old and in good health today, you have time to get a trust in place. Start that 5-year clock and have your home fully protected well before you might ever need Medicaid. An irrevocable trust isn't the only tool available. There are a few other strategies that may work depending on your situation. First, adding the right deed language can make a difference. A lady bird deed, legal in Florida, Michigan, Texas, and a handful of other states, lets you keep full control of your home during your lifetime and automatically transfers it to your heirs at death without probate. In some states, this can also avoid Medicaid estate recovery, though the rules vary, so you need to confirm this with a local elder law attorney. Second, if you're married, spousal protections already give you a layer of defense. Medicaid generally cannot force the sale of a home while a spouse is living in it. However, once both spouses have passed, the home can still be subject to recovery. So trusts remain valuable even for couples. Third, there's a strategy sometimes called the caregiver-child exemption. If one of your adult children lived in your home for at least 2 years before you entered a nursing home, and they provided care that delayed your need for institutional care, you may be able to transfer the home to that child without triggering a Medicaid penalty. This is a narrow exception, but it's real, and it's worth knowing about. The bottom line, there are multiple tools here, but all of them require working with a qualified elder law attorney. This is not a DIY situation. Many people put this off because it feels complicated or because they think they're too young to worry about it. But here's the reality. The average American who reaches age 65 has about a 70% chance of needing some form of long-term care during their lifetime. And the cost of that care has been rising every single year. The best time to protect your home was 10 years ago. The second best time is right now. Here's your action plan for this week. First, look up the deed to your home. Confirm whose name is on it. If it's just yours, or yours and your spouse's, make a note that this is something to address. Second, search for a certified elder law attorney in your state. The National Academy of Elder Law Attorneys has a directory at NALA.org. Look for someone who specifically focuses on Medicaid planning. Third, schedule a consultation. Many elder law attorneys offer a free or low-cost initial meeting. Come with questions about an irrevocable trust, your state's Medicaid estate recovery rules, and what the 5-year look-back would mean for your specific situation. The consultation itself costs you nothing. But failing to plan can cost your family everything you've worked for. Your home is probably the most valuable thing you own, and one of the most meaningful things you'll ever leave behind. Don't let a paperwork oversight undo decades of hard work. The rules around Medicaid and home ownership are serious, but they are manageable when you plan ahead. If this video helped you understand something you didn't know before, share it with someone who's also planning for retirement. There's likely someone in your circle who needs to hear this today. And if you want to go deeper on protecting your retirement assets, check out the video linked right here on the 5 biggest Medicaid mistakes people make after age 60.